that conversation is an unending one. Dr. Monday Ubani, Chairman, Section of Public Interest and Development Law at the MBA, joins us this morning. Thank you so much for joining us.
Thank you.
Well, you've seen the judgment. All the stories are out, and a number of people have also seen the slides we put up earlier. But then there are also suggestions, that maybe there is some press release put out by the court saying, Abia State wasn't involved in that judgment, that it's only Kano State that stands and all of that. Help us understand that, first of all. What's the issue?
Thank you very much. I have a copy of the judgment order. In that particular judgment order, Abia was specifically mentioned. Even though at the last paragraph of his ruling, he made a specific statement that he cannot make an order ordering INEC to issue a certificate of return to any of the other parties. I'm sure the first runner-up in Abia gubernatorial election, that he cannot do that because they are not parties in this particular suit, meaning that there was a prayer for him to order INEC to issue certificate of return, since he has now declared that the votes that was actually given to the gubernatorial candidate then was a wasted vote, going by his ruling. But the good news is that the certificate of return is still with Dr. Alex Otti, and whoever has certificate of return at any point in time will be the one to be sworn in. INEC has not withdrawn any certificate of. I was really surprised when somebody called my attention to that ruling in faraway Kano. So I was wondering, is he before Election Petition Tribunal, because that is the appropriate court that can remove an elected officer. I mean, a candidate that has been elected. So I was wondering. Somebody said, no, it's Federal High Court. I said, on what premise, on what basis? Then in the afternoon, we got a copy of the ruling. And lo and behold, the man said specifically that the vote of Abia and Kano and other states were wasted.
For the Labour Party?
For the Labour Party, were wasted votes and all that. He said it specifically. So we're surprised now to learn a day after that he now issued a statement clarifying the ruling, saying that Abia was not included, that is only Kano that was the target. So I was wondering, was there another proceeding? Because the moment you deliver judgment or ruling, you become functions official, judgment. Did he convey another court who approached him? Was there any application before him for him to make this clarification, or did he just stay in his chambers and issue the clarification over a judgment that he has actually delivered? So it's not too clear. But the point is that we are not taking into all that. The proper thing to do is to bring an appeal, but you seek a leave, from him, since it's an interlocutory ruling, and then have that particular judgment set aside. It can't stand the test.
One of the things that you said now is that this matter, removing a governor is the job of the tribunal.
Yeah.
But then would you say that this is a judgment in that regard, or there are those who would say this is more of a pre-election matter that was ruled on after the fact of the election? Where do we place this?
If you look at the grounds for the case, the removal, the argument is that Labour did not submit the members' voters register 30 days to their primaries, meaning that is a matter that concerns the primary election, and that is a pre-election matter, which ordinarily should have come, since June last year, 14 days after whatever the grievance is. So you waited up till May to now bring a pre-election matter in a Federal High Court after election has been conducted and concluded. It can't hold water. It can't stand. Okay. It is illogical. It is illegal. It's not in accordance with the Electoral Act. It's not in accordance with the Constitution. It's even not. I will call it nonsensical. You don't do things that way. We must try as much as possible to do certain things that people will begin to look at us as a sane nation.
So
it is clearly wrong.
We'll come back. I'd like you to help us understand better.
Yes, sir.
So this is a pre-election matter.
That's correct.
That should have been dealt with when?
That is 14 days after the grievance. Yeah, if you feel that the grievance has happened at any point in time, and it has come to your notice and everyone is aware, that will affect your interest, you rush to court. Okay. It has to be done 14 days. That is the provision of Section 285, subsection 9 of the 1999 Constitution. 14 days. The moment you don't do it within that timeline, it is statute bad. Okay. It can never be revived by any motion, by any order of the court. It's like a rock of Gibraltar. It can't change it. Okay. It's the law of Pesha. It cannot be changed. So, having not done that, an election has been concluded, result announced, a candidate given certificate of return. The proper place now to go to challenge the election and the emergence of that candidate is the Election Petition Tribunal, which is what is taking place now, I think, somewhere in Abuja, and not at the Federal High Court, in as far away Kano. So
it's still a little, it brings back the issue we've always talked about, the judiciary. So a judge entertained this case, yes, which should have happened last year, yeah, and elections held this year. Before the elections held, we didn't hear anything until now, just 1 week or thereabout before the inauguration of this governor, and this is coming to the fore. Yeah. So it raises questions again as to the functions of the judiciary, the independence of the judiciary, the incorruptibility of the judiciary, and the impact of the judiciary on our electioneering, political space. As
I said, I'm also I will deliver a paper by the grace of God somewhere in South Africa in June about the intervention of the judiciary in the electoral process in African continent. It's part of the process. Judiciary plays a very important role. If you feel that there is no compliance with the act governing the electoral process in your country, the only arm of government that can deal with this is the judiciary. They look at it and then make a pronouncement. Provided there is compliance, you don't have any issue. But if there is no compliance, the judiciary will determine that. But in doing that, the judiciary should be also mindful of his role in this particular issue of electoral process. Their role is to correct any infraction of the electoral laws, but not for them to substitute the choice of the majority. In now probably overturning the majority's vote and now giving a minority the opportunity now to elect a leader that will govern a state or a country. So their role is very, very sacrosanct, well defined, and I'm sure most of the justices know about it. Theirs is not to come and substitute whatever the majority have decided at the polling unit. No, it's just look at whether there is any infraction. But most time we are seeing a role being played by the judiciary trying to now supplant the majority in African continent, and we have to be careful to know what the role is of the judiciary is with electoral process, not to come and change the will of the people.
But isn't it also a little curious, Dr. Ubani, because quoting a statement attributed to Mr. Peter Obi, saying if you're going to be called Excellency, yes, then the process that brought you into the office must also be excellent.
That's right.
Now, the prayer, as you said in the quote, is that the Labour Party in Abia State did not present the register of members as part of whatever they're supposed to present to the Independent National Electoral Commission. That is an issue, isn't it?
Yes.
If it is an issue, where then do we place that in the entire
Very
process?
Brilliant.
You said the other time that, okay, it's already started bad because it is late and all of those things. So if the process is faulty, does it mean that we have to sustain the faulty process, simply because it is out of time? It's just a question.
INEC is umpire. INEC is the one that conducts election. I'm sure you are referring to Section 77, subsection 3 of the Electoral Act of 2022. Says every political party must submit the party's register 30 days before the primaries. Yeah. That is there. Now, you ask yourself, who receives the party's register? Is INEC. Now, when you conduct a primary election, the purpose of that register is for INEC to know the members of that political party for the sake of primaries. That is why that particular, enactment was put there.
Yeah.
Now, that enactment did not provide any consequence. Look at it. It didn't say that if you fail, refuse, or neglect, that these are the penalties or consequences. It's not there. There is none. So it's a primary election issue to know those who will now conduct direct primaries leading to the emergence of a political party candidate, is it not? Now, INEC had all that. When Labour conducted their primary election, they submitted the names of those who won at the primaries because INEC monitored the election. Mind you, INEC never complained. General election was conducted in which winners emerged. INEC never complained. INEC now issued certificate of return to the candidates who have emerged. Because at that point in time, these are internal measures of INEC to check whether the parties have complied with the Electoral Act in submission. So if INEC now has not done that, or INEC have seen that those things were complied with, and then candidate has emerged, and then certificate of return given, who is the complainant? Who is not complaining? INEC is not complaining. You that is complaining, are you a member of the political party? Even if you're a member of another political party, do you have locals to come and complain that INEC did not? Let's even assume that this thing you are mentioning now, issue of non-submission of a register, is now an issue that should be decided by the court. We are now saying let the proper court now decide whether issue of non-submission of voters register has now become a qualification issue.
Now,
you know where I'm going to,
but a quick one on that one would now be, is the tribunal also qualified to sit on a pre-election matter?
Now, you are asking me now to decide a matter that is now pending before the court. and I have a right to remain silent on this issue because these are issues now that are before the election.
I asked that question.
No, it's a very brilliant question. Yeah. What I'm saying now, this issue now should be decided by the Election Petition Tribunal. They will look at it, whether this matter, is it not a pre-election matter? And if it's a pre-election matter, is not statute bad? Why didn't you raise that issue timelessly? When primaries were to be conducted, you waited, election is now concluded, result announced. Majority of Nigerians have expressed Abians have expressed who their candidate is. I've been participating in an election since 1999 to date. I have never seen the kind of dancing. I have never seen the kind of joy. I have never seen the kind of jubilation that ever took place in any state like the one that took place in Abia when Dr. Alex Otti was. And I'm saying since 1999, Ubani has been participating in our electoral process in the country. I have never seen the kind of joy. And not only the Abians, the Yorubas, the Hausas, the minorities were all hailing, calling, jubilating, thanking God for the liberation of Abia. So is it anything that somebody now can sit in his room or anywhere and feel that he can now nullify the mandate that has been given by majority of Abians, and the Nigerians will take it? It will not be easy. Well, I'm just telling you this, it's not going to be easy for any person. For whatever it is what. Yeah. We are saying let them go to the tribunal. Let tribunal now look at it. You also made a very valid point, yes.
Dr. Ubani, when you say that this 77(3) of the Electoral Act does not have any consequence to it. How significant is that?
If a law does not prescribe anything, can you now impute that into the law? So is that... Let's assume that particular provision, as I said earlier, was for a purpose. To ensure that the election itself, the primary election, is conducted with the members of the political party.
Which is valid. But the point that point of the question that I'm asking you now is there any culpability of INEC in this? Because it's only Labour Party and INEC that were mentioned, no individual. The statement put out by the governor-elect in Abia State says, look, I wasn't joined in, otherwise my lawyers would have, represented me and all of that. But this issue that you raised, that there is no consequence to 773 of the Electoral Act of 2022, does that in any way validate or invalidate INEC's position?
This matter of non-submission has been decided even up to Court of Appeal. I even heard of somebody said Supreme Court. Before the election was conducted, somebody has gone to court mentioning this issue of non-submission of voters register. And it has been decided by the court that there was valid primary election. So if a matter has been decided by, in pre-election matter, you cannot bring it again even in election.
So because you are saying essentially that this provision is just hanging...
It's hanging there just for the sake of primaries. So if any issue now crops up,
So in
that
other
you are
words,
complaining
yes,
that there was no voters registered before the primary, it's a pre-election issue. That's what we're saying.
So you are saying essentially that whether the party presents a register or not,
Yes.
the primary holds. That's essentially what it
No,
sounds like
I'm not saying that. Say if INEC that's supposed now to look at the issue of compliance did not complain, and now went ahead and put out the name of the person who have contested primaries and won the election. Who is the complaint? It's INEC. It's INEC issue. I'm supposed to give you register. I didn't give you. It's INEC that's supposed to be the complainant now. I say you didn't give. So for non-compliance, I'm not going to even allow. I'm not going to even investigate. Be there in your election. I'm not going to be there in your primary election because you have not complied with the law. But there was no INEC complaint. So who is the one complaining? But assuming that you are complaining now as a candidate, no problem. Go to the Election Petition Tribunal and bring it up. It will now be decided whether it's a pre-election matter or whether it has now fallen into qualification issue under section 177. The court will look at it, okay, does Constitution prescribe that if somebody's party do not submit a voters register, that he has become one of the qualifying criterion? The court will decide it.
Okay. Well, when you're talking about tribunals, the Presidential Election Petitions Tribunal is still sitting, and my colleagues in Abuja would be taking us to the floor to see what is happening right there, right now. Chamberlain.
Oh, just before we go to that floor, you remember that last week there was this back and forth in the courts with the lawyers themselves, and Nigerians are really looking forward to this one. You know why? And that's because, the councils are arguing about different things now. Now, the counsel to Atiku and the PDP, Chris Uche, SAN, prayed the court for an order allowing the televising of the proceedings given importance, seriousness, and national significance of the case. And then that prayer was opposed by the counsel to INEC, Abubakar Mahmood, who says that bringing cameras into the courtroom will defeat the solemn atmosphere that the court is known for. He went further to say that that request for live coverage is unnecessary and uncalled for and should not be granted. In his argument, counsel to Tinubu, Wale Olanigbeku, said he found Atiku's request as not only surprising, but dangerous and capable of prejudicing the court. He also told the court that Atiku should not be allowed to turn the court to a football stadium or a circus ground where all manners of telecast are permitted. He further warned that the requests, if granted, could expose judicial officers to avoidable dangers and demanded that a heavy cost be imposed on Atiku for making that request. But counsel for the APC, Lateef Fagbemi, was of the same view with the counsel to Tinubu and INEC, who faulted the request, adding that the facility and policy documents are not there for the application to be granted. But also, we also do know that much later, Labour Party also applied, saying yes, they are interested in what the PDP is asking. So it will be interesting to see what happens in the courts. But our correspondent, Ella, is there this morning to bring us an update in terms of what's happening, what may likely happen today. Ella.
The Presidential Election Petition Court will this morning rule on the application by the PDP and Labour Party asking for live coverage of the court's proceedings. They said it's for national interest and for transparency's sake. But the APC, INEC and President-elect had opposed it on the grounds that the court is a place for serious business and not a marketplace or a circus ground. The court has also hinted on consolidating other petitions by the PDP, the Labour Party and the APM. But the counsels for all sides asked for time to consult with their clients and revert to the court. That is expected to come up this morning. From the Court of Appeal, venue of the Presidential Election Tribunal, Emanuela Ekele reporting for Channels Television.
Well, thank you, Ella. Well, when you talk about live coverage, you know the media will be interested. And by the way, there are several ways of broadcasting scenarios. It doesn't necessarily have got to be on traditional media. It could be on online platform. There are different ways. In fact, some lawyers also did say, look, why are they acting as though this is strange? In Kenya, in South Africa, they see similar things going on here. So, and besides, once upon a time in this country, when certain things happen, they didn't show the faces of the judges. It was just the proceedings that behind this, opposite the lawyers who were seated, but you could hear what the judges were saying. So not putting faces to those voices. So different perspectives, different arguments, but who knows what to expect this morning.
Indeed, Chamberlain, I think that the judges will certainly have their work cut out for them, but I think what will be very important will be how they eventually rule, and you know, perhaps if the judgment will be unanimous, or whether you're going to be seeing them split right down the middle, whether it's going to be something that majority of the judges will say yes to or no to. We'll see how that really eventually plays out. But some people have also spoken about the possibility of a compromise, because people have spoken about the language of the court. I mean, how many people really can understand the proceedings of a court in terms of how things eventually go down? How is this going to interest the generality of people who are talking about live coverage? People really understand the breakdown, but people are saying that perhaps at the end of the day, what might be a compromise might be delivering the judgment on live cameras. We saw that with the Ekweremadu case, where the case was run not in front of cameras, but eventually when the judgment was given, the judgment was done. The judge was filmed, and all the over about 40 minutes of the judgment delivered by the judge was filmed, and I think it was broadcast. So people were able to watch that judgment, you know, at their own convenience and see just how the judge arrived at his decisions. And I think that's what a lot of Nigerians are really interested in. At the end of the day, when all of the counsel have put forward their arguments, people want to know how the justices of the Court of Appeal, which is the first court of instance in this Presidential Election Tribunal matter, or Presidential Election Court, as it's now called, you know, will arrive at their decisions. They want to know how the different matters that have been brought before them were decided upon. I think that for a number of people, that's the meat of the matter. The theatrics will most likely will say, I mean, lawyers will always be lawyers. They are there for a reason. It'll be interesting to watch, you know, never mind the language. It'll be interesting to watch. But I think at the end of the day, for a number of people, what they really want to know is how the judges will arrive at their decision.
And you know, if in that light, people want to understand the how, it will help the court. It will help the people understand what transpires in court, how proceedings, how things go, so that possibly it may change their perception about the judiciary. You never know. I mean, people internalize things differently. But on the other hand, it's also different because it's a global village. The world is changing. People want a lot more information, and they want it when they want it. They want to have a lot more say in what happens in different areas. In some climes, judges are elected. And so, yeah, but here, so many traditions, even in some other countries where these things play out. So, but the way this is done, anyway, I don't know how the pendulum will swing.
Do we really want our judges to go down the path of election? Look at how politics
just because, look, when they come on this show, you hear them tell you, oh, in that country, this happens, in that country, this happens. But you don't hear them tell you some of the other things that happen in those countries and how they arrived at those scenarios. But without asking Mr. Ubani to speak about the prayers before the judges, Mr. Ubani, I mean, do you understand when you're on cameras, what people see, how they react to things? You also, in the Temple of Justice, you go there time and again to plead your case. Do you understand why people are asking what they're asking, and what do you even expect? What goes through your mind when all these cases are going back and forth?
You guys are too informed. I listened to your argument. Honestly, I aligned myself with everything you said and Maokwe. The world has actually taken a leap. The world is moving fast. The advancement of technology almost in every facet of life, you know, has actually taken it up to the extent that if people still think we're in 20th century and all that, they are not right. There is so much advancement. And the issue of getting people to participate in everything that has to do with them is a new thinking. We are in a new era. And we see all these nations doing that are even conservative, you know, with regards to legal profession, are all making moves, you know, to change their old ways of doing things. Because technology, every day there is something that is happening in the world. I wrote a paper yesterday on issue of ICT in administration of justice in Nigeria. We are so backwards. If you go to Rwanda, if you go to Kenya, all their decisions are completely taken over by ICT. Everything from beginning, the filing, the proceeding, the judgment, even the obtaining of the copy of court judgment is under ICT. But here, everything is still done manual, and that's why people can still argue oh, that you cannot have a proceeding televised. Because we are still thinking as if we were in the 19th century. The world is moving. We have so much advancement in technology. So also people are advancing. Our knowledge also. Even the eagerness to participate in every process in governance and all that, so is also advancing. So I align with all your argument, but the matter is still being going to be decided. It's when they decide that we can now look at the reasons they have given, whether it's really suitable with the new era in which we're in, or whether we are still thinking as if we're in 17th century. So let the judgment be given as to whether they will allow live cast, on this proceeding that is supposed to take place. It's a very important, matter in our national life. The issue of deciding who is going to be the president of Nigeria in 2023 for the next 4 years, and the matter is being challenged in court. So it's important. People want to know how this matter is decided. It's important that they want to know how it's decided. And so I align with you guys. Are well enlightened. You have analyzed it. You have spoken so well. But let's see what the decision of the court is concerning this matter. So if they agree with the applicants, fine. If they agree with the respondent, fine. But we now come and look at the reasons, and then look at what happens in other nations, and then look at whether we can make some level of progress with regards to whatever the ruling of the court will be. So wait. Today is the D-Day.
All right. We'll see how that plays out. So, Ayo, we're going to hand back to you.
Well, thank you, Chamberlain. Just a quick one on the conversation we were having earlier. Yes. So what happens to this judgment now? I mean, going by the information that the candidate of the governor-elect in Abia State has put out.
I want to make it clear that the candidate, the governor-elect, is still with the certificate of return. It's not taken away. But for whatever is worth, appeal will be filed against that ruling of the court in order to set it aside. There will be a motion for stay to avoid anything, because I understand that they're making move to go to INEC for INEC to give them interpretation. So I don't know what they want INEC to interpret, because these guys are desperate. They want to stop the swearing in of Dr. Alex Otti, which I have told you is a mandate given by the people. Nobody has a right to take it away. God himself will not even do it, because the mandate of Dr. Alex Otti is divine, generously given by the people of Abia. So I don't think that any court at this point in time will want to tamper with that particular right that is given by the people. So, but whatever it is, the matter is before the Election Petition Tribunal. They will decide that, not the Kano court. The Kano has no jurisdiction over this matter. But for whatever is what, the lawyers are taking steps in order to have it set aside on appeal. And that will be done. The paper should be either filed today or tomorrow. So we're not taking it lightly. We're not sleeping over it, that, oh, maybe it's a useless judgment. No, every judgment, no matter how useless, must be set aside, or else they can use it to cause some level of collateral damage.
Well, it's a conversation that many Nigerians are definitely interested in, because a simple Google of the name of the governor-elect or Labour Party, it's one of the first things that will come up. But thank you for the understanding you've given this morning. Dr. Monday Ubani is Chairman, Section of Public Interest and Development Law at the MBA. Thank you again.
Yes, I will be stepping down as Chairman of SPIDA this year. We're having a conference in Lagos sometime in June. Channel will be invited. And
but you have not stepped down.
I have not stepped down.
The same way the members of the National Assembly are still.
I see there. Yes. Okay. I'm stepping down in June by His grace.
All right, thank you again for your time this morning.